So my esteemed panelist Chirag ji, Hifazat Ali Sayyed ji, Aishwarya Chandran, other learned colleagues, team members of this program, students and other scholars. This is a moment of great happiness for me that I am trying to share my views on such a contemporary topic which does not finds headlines the way other topics are finding. We discussed on various topics in last maybe since the webinar started, the phenomena of webinar started. We discussed on COVID, we discussed on free speech, we discussed on CAA, we discussed on many other topics, gender justice. I think out of many discussions, this has attracted my attention because it has tried to address the real issue. So I congratulate the Center for Criminology and Criminal Justice, especially Hifazat Ali Sayedji and his team, for conceiving this idea. I also wish to record my appreciation for 3 points that has been raised in advance so that our discussion remains focused. That indicates that the producers or the presenters, they want to be more serious to the discussion, and something very useful, something meaningful comes out of discussion. These type of discussions, I often say, are not just academic discussions. Fundamental duties in the Constitution of India, 51A, Clause H, this is a command of fundamental duty to create scientific temper. So what you are doing and what we are participating and what other students are here, we are not just doing some academic work, but it is a command of duty, fundamental duty that we are discharging. The topic is quite relevant and it is especially focused on 2015 amendment. So I have also focused my discussion 2015 amendment. Now, a brief legal framework, because I'm a first speaker. Article 17 talks about abolition of untouchability. One of the greatest shame of India, especially among Hindus, was untouchability, is untouchability, not just was. It has been abolished in 1950, but we keep on reading in newspapers how it is being practiced. Fortunately, not as grave as it used to be in 50s, 60s or 70s. We all know that Article 17 also declares that it has to be an offense. In one discussion with Professor Upendra Bakshi, he pointed out that Anurag, you see, probably there's hardly any constitution which declares something as offense. Constitution are made to declare principles, policies. They do not declare offense. But our forefathers were so concerned for such practices, be it untouchability or be it bonded labor, they thought it to give a constitutional recognition and a mandate to the parliament that it has to be declared as an offense, and therefore Article 17 followed by Article 35 Clause 2 mandates parliament to pass penal laws And then in 1955, Untouchability Offences Act 1955 was passed. It was renamed as Protection of Civil Rights Act in 1976. Then, because of certain lacunas, Scheduled Caste, Scheduled Tribes Prevention of Atrocities Act 1989 was passed. Rules were framed in 1995. They were amended in 2016. Then there was sixth report on Standing Committee on Social Justice and Empowerment, 2014. They have submitted a report. Based on that, Amendment 2015 was brought in. There can be many heads of this amendment, but for the purpose of convenience, I have placed 4 such heads. One is criminalization. So this amendment of 2014-15 further criminalizes various conducts. Scst Act already criminalized a number of conduct. 2015 Act has further added to the criminalization. They added to the criminalization not just the number of offences have been added, but the nature of offences has also been changed. Some of the issues which are constitutional in nature, they have also been given a recognition so that penal law can come in force. For example, right to vote. So voting right is always there, but it is no secret that vulnerable group people, especially SC/STs, they were debarred to cast their vote in many places. These days we do not hear it often, but maybe if we go back to maybe 20 years prior to TN session era, or maybe during TN session era, this was just everyday feature. Then property, which is still there, problem of property, that their lands, either misusing their position of poverty and ignorance, their lands are grabbed, or because of any other reason, without consent, misleading these people, lands are grabbed. So there is an offense especially created for that purpose. Women's security has also been addressed. We know in 2013 various amendments have been made in IPC itself. But then in 2014-15, women's security was addressed, and few offences were repeated in the sense that they are already offences under IPC, they are already offences under maybe POCSO, they are already offences under other laws, but under SC/ST Act a special recognition has been made. Dignity has further been acknowledged. So now name calling with caste, that has been made offense in a far more better manner. It was already an offense, but it was far more better manner. It was made an offense. Regarding criminalization, I would say that Indian scenario is quite different from many other countries, and therefore 2015 amendment has made name calling or caste calling as an offense. That cannot be made an offense maybe if you follow Western doctrine of free speech. Western doctrine of free speech, for example, clear and present danger test in the USA, they cannot allow these type of laws. Name calling cannot be offense. For example, in 1969, in the USA, a case was decided that was known as Brandenburg versus Ohio, and it held that unless there is a clear imminent tendency of violence, you cannot criminalize any speech. So if I just name a person with his caste and no reaction takes place, That means that free speech is permissible in USA but is not permissible in India, and rightly so, because our case is entirely different, and Dr. Ambedkar and his team has indeed rejected this clear and present danger test. Second aspect of 2015 amendment is enforcement. So the enforcement means the criminal law comes in picture when an FIR is registered. There are preventive measures also, but FIR initiates a criminal procedure. Section 4 makes a special provision that the FIR is duly registered, witness is duly heard, the record of FIR is duly given. Provisions which are already there in CRPC, they have been incorporated, and it has been made penal that if a police officer willfully neglects his duty of registering FIR, not taking application, not behaving in a proper manner, the witness or victim, finding fault in victim. So if these things are being done, then the police officer can be prosecuted. I shall try to come to section 4 again. Then second aspect of enforcement is investigation. That investigation used to take place, officer in charge of police station does it, but DSP has been authorized under, not under the act, but under the rules. Why DSP? Because DSP is supposed to be better equipped, and therefore investigation he is able to collect. He is far more senior also, so he will collect better materials that could lead to conviction. But the problem that is coming because of DSP is that there are not enough number of DSPs. So one of the problem is that one DSP is involved in many cases and the investigation do not run in a proper manner. Third is exclusive special courts. We have heard about courts, we have heard about special courts, but there is exclusive special courts. Exclusive special courts is mandated to try cases under SC/ST only, because this committee, sixth report of standing committee found in 2014 report, it has referred data of 2013, that the pendency rate is increasing every day. It has increased to 81% from 70%. So therefore exclusive special courts are required, and therefore this recommendation was accepted. Then special public prosecutor. These are the provisions, some provisions. Then evidence. The area of evidence has also been little bit modified. Section 8 has been incorporated, and presumption clause has been added in this 2015 amendment. Then special chapter 15A deals with rights of victim and witnesses, which is our focus. But section 15A only does not only deal with rights of victims. Section 4 also deals with rights of victim. Section 8 also deals with right of victim. Yes. Now section 4, it has addressed the problem of non-registration of FIR. Every day, means CRPC provision is there, so many provisions are there, courts are there, But still, this simple problem of FIR, we are not able to tackle. Every day there are questions whether FIR is registered or not. Even if I have to go to register an FIR, suppose my mobile is snatched and I want to go to register an FIR, I doubt that whether it will be registered because I have a better experience. My mobile phone was snatched and I went to Ghaziabad, one police station, and you won't believe that from 8 p.m. to 3 a.m., 7-8 hours I had to stay there in the police station so that my FIR can be registered. I am LLM from BHU, PhD from Gorakhpur University, teaching in ILI. You can understand the situation. If a police station can ignore, can delay the registration of a PhD holder in law, what will happen to these people who are very weak, who do not know what law is? Many of them are illiterate. So FIR is a big challenge, and this has been addressed by making it punishable. That if you do not register FIR, then it will be punishable. But the problem is that will it change the scenario? I think this will marginally change the scenario. Why this is so? Because we have previously made changes. For example, in 2013, 166A, capital A was incorporated in clause C or clause 3rd. We have made it that in case of crime against women, FIR has to be registered. If I is not registered, then it will be a penal offense. But every day we are finding that even rape cases in many cases are not registered, and nothing happens to police. 166A cases are not registered. Sometimes some suspension, sometimes maybe transfer, but FIR is not registered. There are, I think you can just count FIR. Supreme Court in one Suomotu case has asked the central government and the state governments to inform that in how many cases FIR has been registered under 166A clause 3. Similarly, under POCSO, if the police officer fails to record, section 19 says that FIR will see that is a penal offense. Way back in 1861, in the Police Act, there are at least 3 provisions. Section 23 talks about duties of police officers. It clearly says that police has to register, police has to do as per law. Otherwise, it is a penal offense. They will be punished. Similarly, section 29, penalties for neglect of duty. 3-month punishment is already there. It was made in 1861. How many times these provisions have been applied? So my hunch is that even section 4, which is incorporated, will remain like white elephant. Means it is not being enforced. So the main problem is how to enforce these things. Section 8 deals with presumption clause. I am skipping this part because it mainly deals with accused, goes against accused. Of course, it also in favor of victim. Conduct is presumed, causal relation is presumed, mens rea is presumed, provided 1-2 elements which are mentioned under section 8A or B is established beyond reasonable doubt. So this presumption is good. I think it is good, but there are 2 dangers. One is then reasonable suspicion is made an offense. Means if there is reasonable suspicion, then not made an offense, but reasonable suspicion is there, then presumption comes in picture. I think this is a little bit harsh, and the court has to be very, very careful. Secondly, common intention is also presumed, knowledge is also presumed. So chances of misuse increases, and therefore police as well as the magistrate has to be extremely careful. I am trying to place next two slides from one of the dissertation work submitted under me by my student Gurudat. He has done his work on enforcement or the impact of this exclusive uh, courts that is made under section 14 of 2015 Amendment Act of SC Act. He has done his studies in a study period by January to May, and his empirical studies on Ghaziabad, Varanasi, and Kanpur. He had made a comparative study. He found that UP has a better conviction rate, though it has the largest scheduled caste population. Time is passing, otherwise I would have shared the chart also. However, he suggests that his finding is that exclusive special courts are 195 only. We have 725 districts, dear friends. 195, not in half of the district. So we need exclusive special courts, if not in all places, if not in all districts, but at least half of the districts can be covered. Exclusive special public prosecutor is provided, but in Ghaziabad, in Kanpur, in Varanasi, there was no exclusive special public prosecutor. One public prosecutor said that he has 20 cases per day where to appear. So many cases he just takes adjournment. This is the case of Ghaziabad. Now, special court is the state responsibility. It is not the central responsibility. And special public prosecutor is also a state responsibility. So states are a bit failure in this. There are cases which are pending for last maybe 20-25 years. Now, exclusive special courts have been made, but what is so exclusive in that? In Ghaziabad, exclusive special court, the court was also dealing with Motor Vehicle Act. In Kanpur, exclusive special court, many cases were not under SC Act but under different acts. So we can understand that if exclusive special courts will deal with these matters, there will be two problems. Number one, they will not generate an expertise on these, and secondly, the time will be taken away by other matters also. So we can see that strength of judges. So some of the problem is because of strength of judges. 16,726 judges are currently working. Judges means subordinate court judges. I'm not counting High Court or Supreme Court judges. 16,726 magistrates are working in the subordinate courts, or subordinate court strength is 16,726, but the sanctioned strength is 22,474. So around more than 3,000 posts are still lying vacant. 4,000 posts are lying vacant. This is the responsibility of state and the high courts. And what are these states and high courts doing? If the posts are vacant, why are you not filling the post? Staff strength is also not good. In Varanasi, in the special court, the reader went on leave, and for 1 week nothing could be done in the court because reader was on leave. There was only one reader. The magistrates who deal with SC/ST cases, they are given additional responsibility like RTI. There is a provision of witness incentive. Section 15A provides for incentives to witness, in the sense that if they come to the court, victims come to the court, witness come to the court, then some payment would be made. It is not just incentive, it is a matter of right. But the victims and the witnesses inform that he was entitled to get 6,500 rupees, but half of the money was shared by the court staff and the police. In Ghaziabad, Kanpur and Varanasi, in these 6-7 months, January 2018 to June 2018, cases were decided and 29 cases led to acquittal. Out of 29 cases, 13 cases were because witnesses turned hostile. And if the cases will go for longer and longer period, it's obvious that witness will turn hostile. So framing of charges are other problem, because all accused required to be present, and accused therefore use the trick that they are not present, so that the case lingers on for longer period. Now I think because of virtual hearing type thing, two things can be addressed. Number one, during framing of charges, if some accused says that he is not able to come because of some reasons, then his virtual presence can be considered, and therefore to some extent, not to all extent, to some extent this can be addressed. Even if there is one public prosecutor who is having 20 cases, if we can appoint public prosecutor, it is good. If we cannot appoint public prosecutor, then the same can present himself through virtual hearing. So at one place he can stay, and from that place he is not required to go to one court to other court, but he can address the courts with the help of virtual hearing. Therefore virtual hearing has come as a boon, and therefore E-Committee Court of the Supreme Court has rightly done that it has now started considering hybrid mode of hearing. Now, I dealt with the Telangana. There are the strength of the subordinate court is 474. 378 is the working strength, means working strength people working, but 96 posts are vacant. Similarly, I am skipping these. So, similar is the case of High Court. In High Court, many vacancies are there. For example, 419 vacancies are still there in High Courts. So therefore, to conclude, because my time is over, I would say that enforcement is a combined collaborative process, and there can be enforcement of law. We have enough laws, we have very good laws, we need to enforce these laws, and there can be 5 key drivers for enforcement. One is educative. Educative means we need to educate. We need to educate victims, we need to educate magistrates, we need to educate public prosecutor, we need to educate police, we need to educate common persons also. For example, if we see something wrong is going on under Scst Act, then we should inform the police. So this is educative. Second is persuasive. Now persuasive means we need to persuade. So these seminar conferences are way to persuade people that law is there, we need to enforce it, and how to enforce it in a better fashion. Third is the compulsive mode. Compulsive mode means, for example, FIR is not being registered. So can we use technology to register an FIR? Now cell phone and smartphones are available. Online FIR has been started. Can we make it possible that all SC/ST cases can be registered online also? That with the use of technology, all cases of SC/ST registered online. If they are registered online, once an FIR is registered, police will be bound, which will be compulsory for the police to make investigation. Fourth is coercive method. Coercive method means if the police is not registering FIR, if the judges or the magistrates are negligent, if public prosecutors are negligent, then administrative measures can be taken. For example, Section 7 of the Police Act talks about administrative measures of suspension and some punishment and 15 days salary cut. This law is already there, this law is not being used. The coercive measure and the punitive measure which is there, under section 4 of SC Act, which can be used if the offences are against women, like rape is committed against a SC lady, then section 166A also comes in picture if FIR is not registered. So punitive measures are also there. So I think these 5 key drivers needs to be focused, so that the laws which are already passed, they can be enforced well. I'll just conclude by a small illustration. During COVID, uh, what we have done, we have purchased masks, but we have also used our hankies, because mask we were not used to, and mask used to it is not washable. So we use, and I have used hankies. So I already had 6 hankies. I started using hankies in order to secure my mouth and my nose as per government guidance. But when I started using, I found that every alternate day, uh, my hankies are lost. And I used to yell on my wife and my children, where are my hankies gone? And they said that you are not keeping your hankies in a proper fashion, proper way. Please keep it safe and keep it in a particular place. You throw it here and there. Then I purchased 6 more hankies. But even after 2, 3, 4 days, I found that all the hankies are lost and I am not able to use hankies. And again, I accused my wife and my children. Fact was that I was not using my hankies in a proper fashion. Means I'm using it and I'm throwing it in any place, not washing it properly, not washing it every day. So even if I buy 6 more hankies, that will not change the situation. Similarly, dear friends and learned uh, members, faculty members, teaching faculties, fraternities, we can make many laws. We have Police Act of 1860, we have IPC of 1860, Police Act of 1861, IPC has been amended, POXO is there, and then SC Act is also there. But unless we change our own attitude, unless this system changes its own attitude, and unless the academicians start focusing on these type of issues also equally, the way they focus on free speech, the way they focus on other issues, we should give equal focus on these type of issues. Only then the things will start moving in a positive direction. I thank again for this patient hearing, and I thank the members of Symbiosis for inviting me. Uh, Questions are welcome as per the rules. It can be asked now, or as per once this once all the panelists are over, the questions can be asked. Thank you very much.
Thank you, Anurag, sir, for shedding light on this very informative subject, especially for drawing parallels between our current situation with COVID and virtual hearings. I'd like to call upon Mr. Chirag, sir, to address the remaining points of discussion.
Thank you, Aishwarya. And I would like to thank the organizers, Professor Azad and Professor Anurag, for addressing an important issue which requires a lot of attention. A lot has been said and covered by Professor Anurag, and still much can be discussed about it. Professor Anurag started with the Constitution and reminded us what Professor Upinder Bakshi said, that Article 17 is one of the unique articles wherein it is provided that state can enact a criminal law on the subject matter of untouchability. Similarly, we have Article 23 where state also positively prescribes that child labor can be criminalized.